Okay, then defamation we have again seen in civil as well, right? In torts also we have seen defamation. Similarly, provisions are there in IPC as well. So defamation is an offense affecting a person's reputation, and it is covered under chapter 21 of Indian Penal Code. It is one of the, towards the end, this provision is there in IPC, that is section 499 and section 500 of IPC. 499 mentions what defamation is, 500 provides for the punishment for defamation. So just like any other property, like we have seen offenses affecting person's body. Body is also nothing but a property that a person possesses. Offenses affecting property of a person, movable, immovable, all those are covered. Same ways, when we talk about reputation, it is also as important or even more important than property that a person possesses. So it is very important that the person's reputation is being protected, and if another person without a lawful justification tries to lower reputation of a person, he can file a case for that also. So that is nothing but defamation. Defamation, as the meaning of the word suggests, it is nothing but an injury to the reputation of a person resulting from a statement which is false. Now, this is very important. Whatever statement is published regarding the person, it has to be a false statement. A man's reputation is treated as his property, and if any person tries to damage or lower his reputation, it is considered as a crime under IPC. Section 499 providing for what defamation is. Section 500 provides for the punishment. So when we talk about defamation in civil law, amount of compensation can go up to any amount if they can justify that this is why that much amount is claimed. If justification can be given, they can claim for any amount. But when we talk about criminal law, the punishment is not like too much also. It is just simple imprisonment for a term up to 2 years, or with fine, or with both. So sometimes only fine may be imposed and person may be released also. That's the reason mostly we see that civil suits are being filed for defamation. Okay, there was one case you might have heard, Prasad Bhushan. He posted something against Chief Justice of India and Supreme Court on his Twitter, and case was filed, and the person was given punishment also of 1 rupee. Okay, so this is nothing but affecting reputation of a person. Now we have some essentials of defamation. So when we talk about defamation, whatever statement we are referring to, it must be defamatory. It should not happen that only I feel like that statement is defamatory. It should be that if a person, right, if a person of ordinary prudence hears that statement, that person also would feel like it is defamatory. That is very important. So the first essential of the offense of defamation is that the statement must be defamatory. That is, it must be something which tends to lower reputation of the plaintiff who is filing the case. The test to check if a particular statement is defamatory or not will depend on how the right-thinking member of the society are likely to take it. So if we tell that statement to any person, how a normal person is going to understand, or how a normal person is going to interpret it or take it? Is it that they are going to think bad about this person or what? Depending on that, we can decide whether it is defamatory or not. Further, a person cannot take a defense that the statement was not intended to be defamatory, although it caused the feeling of hatred, contempt, or dislike. So the person who published the statement, he cannot say that, no, I did not wanted to lower his reputation, or I never thought that people are going to interpret in this way. Right? So we need to see that how a person is going to take that statement. Based on that, we can decide if it is defamatory or not. So A publishes an ad in a local newspaper stating false information that the company of B has committed fraud of 2 million. Now the statement will amount to defamation, as this newspaper will be read by many readers and will surely injure reputation of B's company. Okay, so in such a case, we will say that it is nothing but the statement itself is defamatory, which is going to lower reputation of this company that it has committed fraud of 2 million rupees. When the plaintiff files the case and says that there is publication of some statement, the statement that we are referring to, it must refer to the plaintiff. Okay, so plaintiff should not himself feel like, okay, this person said that statement referring to me or something. It should actually be a statement which refers to the plaintiff. So in an action for defamation, the plaintiff has to prove that whatever statement he is complaining of, that statement actually referred to him only. And to whomever we tell the statement, that person is going to think about him. Okay, like if you say that, okay, the tallest person in our class has done this, and there is only one person who is like the tallest, okay, and everybody knows it, that okay, you are referring to this person only when you are saying tallest person, right? In such cases, we will say that it is also defamatory, even though you have not taken name of the person, but you have given enough description. Might be the tallest person who comes from this certain road, who lives in this particular place, has done this, right? So in such cases, it is understood. Whomever you tell, that person is going to interpret it in that ways only. That tallest person means this person. So the statement must refer to the plaintiff. And lastly, what is important is the statement must be published. So publication of defamatory statement to some person is very important other than the person who is defamed. These are similar to the defamation that we saw in torts as well. Okay, so whoever the statement that is there, it's not like one person has some things about another and he is directly telling him. It should be told to somebody else, to some third person. So letting a third person know about it is nothing but what publication means for the purpose of defamation. If a defamatory letter is sent to the plaintiff, is likely to be read by someone else, there will be valid publication. Like what happened in this case is, the defendant was held liable for sending a defamatory letter to plaintiff. Now, letter was addressed to plaintiff only, but it was written in Urdu, wherein the defendant knew that plaintiff did not know how to read Urdu. So in such cases, when you are reading it in a language that you know that this person cannot read, you have an intention that, okay, this person is going to read it in front of, like request somebody else to read it, and that's also nothing but publication. So this would also be counted, that with an intention that somebody else is going to read it for the person, it was wrote in that particular language, which the defendant knows that plaintiff is not able to read. So that is also going to be defamation. When we talk about types of defamation, it is again of two types: slander as for spoken words. So defaming a person by way of words or by way of gesture, it is nothing but slander. And when we talk about libel, it is in a permanent form in some written or printed mode, which is going to last for a longer time. Okay, so the ingredients and everything is same, essentials and all are same, just like law of torts. Okay, there is another concept that we have. Okay, that is innuendo. So statement is prima facie defamatory. What is innuendo? It basically means like a statement having a secondary meaning. Okay, sometimes we might say it in a certain way that first when you hear the statement, you would feel like, okay, there is nothing wrong in this statement, but actually there is like a hidden meaning in it, and that hidden meaning is nothing but what is defamatory. So initially when you hear it, you might feel that it is like an innocent statement, it is a proper statement only, nothing is wrong, but later you would realize that there is a secondary meaning attached to it, and that is nothing but innuendo, which would also be considered for defamation. Okay, so take for example, Jed makes a statement that X is an honest man. So when you hear that, okay, X is an honest man, fine, he is an honest man, but there is something else also to it. X is an honest man and he never stole my watch. So when you hear it, first of all, the person is saying that, okay, he is an honest man and he never stole the watch of that person. But later on, you will realize that no, actually, there is a hidden meaning to it. Why did the person say he never stole my watch? That means might be he only was the one who stole his watch and he is actually not an honest man. So the statement, when you hear it for the first time, it looks all fine, all good, but later on we realize that there is a hidden meaning to it. Okay, and any normal person is going to understand it in that particular way only, that actually X is a dishonest man and he only have stolen the watch. So this would also be considered under defamation. Okay, now defamation can be referring to a person, right? Like the tallest person in our class, or X, Y, like that. Or it may be of a class of persons also. Okay, so defamation of a class of person. So sometimes it might happen that the defamatory words, they refer to a group of individual or class of person. It's not just one single person, but it is a group of person. So in such cases, no single person of that group or class can sue unless they can prove that they are the words would reasonably consider to referring to him, because it was referring to a group of people or a class of people. Like, for example, if a person wrote that all doctors were thieves, then no particular doctor could sue him unless and until there was anything that was pointed towards one specific doctor. But they can file a case like a class, okay, like class of person or group of person. So this situation will be different if a person wrote that all doctors of Gangaram Hospital are thieves, and then the doctors of this particular hospital only can sue him for defamation. So sometimes we would see defamation is of a class of person also. Many times, in fact, we see, right, that lawyers are this, doctors are this, professors are this. This is nothing but defamation of a class of person or a group of person. Okay, now there is something called as communication between husband and wife. In law, husband and wife are considered as one person. Okay, so whatever communication happened between husband and wife, it is called as privileged communication. That is why if husband or wife has committed a crime, okay, if either of the spouse has committed a crime, court will not call the another person and say that so and so is your husband or wife, you might be aware of the crime, tell us. That will not happen, because it is considered as privileged communication. Okay, whatever communication happened between them, court is not going to call the other spouse and be like, you tell how your husband or wife has committed this crime. Okay, same ways for the purpose of defamation also we call it as privileged communication. So if there is some sort of a communication between husband and wife, wherein husband says bad things about another person, wife says bad thing about another person, that will not amount to defamation. Okay, because this communication is privileged communication. There was this case, in fact, wherein letters were written. Okay, husband wrote letters to the wife, which contain defamatory matter. He wrote bad things about his father-in-law. Okay, so letters were there from husband to the wife containing defamatory matter concerning the father-in-law. And court said that this will not amount to defamation because the communication between husband and wife, it is considered as privileged communication. You will get one topic also under Indian Evidence Act. Communication between husband and wife, and also communication between advocate and client, that is also considered as privileged communication. That's why client is going to narrate the entire story and then advocate would try to like defend him, right? Court is not going to ask, okay, you are his advocate, you must be aware how he committed the crime, tell us. That never happens. Okay, now there are certain defenses in defamation, just like how we saw in torts. Justification or truth. The person can prove that whatever statement I have said, that statement is in fact a true statement. Okay, so justification or truth. In a civil action for defamation, truth of the defamatory matter is a complete defense, and the reason for this is that law will not permit a man to recover damage for something which is being true about him. Okay, so in such cases, truth of the statement is going to be an absolute defense. In criminal law, we also need to prove that whatever statement is published, it is published for public good. Okay, there is as such no bad intention of harming the person. The statement was published for public good. So if the statement is true, the person can prove that whatever I have said, this statement is actually a true statement. Then we have fair comment. So fair comment on matters of public interest is also a valid defense. So sometimes we might say that it is a comment, that is, it is expression of my opinion, what I feel about a certain thing. Like when a new legislation is introduced, many people start to analyze it and provide their comments, right? Recently, there were changes in income tax, the slabs, right? And a lot of people started commenting on it. That would fall under this, that it is a fair comment. They commented what they feel about it. Is it going to benefit people or not? Whom is it going to benefit and whom not? That is nothing but fair comment. Same ways when a judgment comes, like a landmark one, people start commenting on that also. All of these are considered as fair comments. When we talk about comment, it must be a fair comment, not like that I can say anything and then be like it was my comment, just what I feel. That will not happen. It must be a fair comment. So the comment should be fair, that is, should not be based upon untrue facts. X publishes serious allegations of bribery against Y in a newspaper. Later, X is not able to prove the truthfulness of the statement. Therefore, his comment will not amount to fair comment. Why you made that comment, you should be able to justify that also. Okay, so that is nothing but fair comment. And whatever matter they have commented, it must be in public interest also. So that also is very much important, that it is in public interest that the matter is published. Matters like administration of government departments, courts, ministers, public meetings, textbooks, etc. are considered to be matters of public importance. Many times you will see people commenting on what chapters are included in a certain textbook, like school textbook, right? This certain chapter is included. Why not we are studying about this certain thing? Why we are studying about this, like why this certain information is added in a textbook? Like that you will see many times people comment or people write on newspapers also about those things, that this certain thing should not be inserted in this way in a school textbook and all of that. Those are nothing but fair comment, that too in the interest of public. How the government departments are functioning, right? Like some websites are not working, maybe some departments, there are, like too many leaves are being taken by the people. Like schools, you would see schools are not functioning properly, adequate teachers are not there, courts are not having enough of judges. All these are nothing but fair comments in the interest of public. Okay, so justification, fair comment, and lastly, it is privilege. Sometimes we can say that it is a privilege. Whatever statement I have published, that is a privilege. So privilege can be absolute privilege also, or qualified privilege. When we say absolute privilege, like it may be related to parliamentary proceedings. Article 105 of Indian Constitution gives immunity to parliamentarians to speak anything during the course of business. At the time of session, whatever they are saying, whatever statement they are making, for that there will not be charges of defamation. So they are getting immunity under it. It is nothing but parliamentary proceedings. When they are in session, it's not that a member of parliament would say whatever he feels like uh, in his private life also. It is during the session, during business of parliament, whatever he says, from that immunity is given. And that is nothing but absolute privilege. Same as judicial proceeding. Protection is given to judges also under Judicial Officers Protection Act 1850. And this includes counsels, witnesses, parties, etc. as well. Okay, there can be qualified privilege also. This privilege is available, and under this it is necessary that the statement must have been made without malice, that is without wrongful intention. So I was not having any wrongful intention and I made this particular statement. For example, a shopkeeper says to B, who manages his business, sell nothing to Z unless he pays you ready money, as I'm doubtful of his honesty. Now, A will fall under this exception if he has made this imputation to Z in good faith for protection of his own interest. Right? The business, whoever is having a shop, running a shop, it's very difficult for them to track how much money they are to receive from whom. And sometimes people would say that, okay, give me this goods, I will pay you later, but it might not happen ever. Right? So this person can say, in order to protect his business, he might say that, okay, sell nothing to Jed unless and until he is ready to pay the money, then and there only. So in such cases, we can say that it is qualified privilege. The person was not having any wrongful intention as such, but he just wanted to protect his own interest. He just wanted to protect his own business. Okay, so section 499 of IPC, it provides for what defamation is, and we have two different types, libel and slander. Both are considered as criminal offenses in India, and there are certain justifications as well which can be proved by parties in order to escape the liability. Okay, so there was this case wherein petitioner was stalked online and the fake account was created in her name. Additionally, obscene messages were also sent to friends by the culprit with an intention to defame the petitioner. High Court of Orissa held that the said act of the accused falls under the offense of cyber defamation, and the accused is liable for his offense of defamation through the means of fake obscene images and text. Because sending that, by way of sending those obscene messages, her reputation was lowered in front of her friends. Right? So in such cases, it was considered as cyber defamation because again, there was no lawful justification for that. Is it clear?
Yes, ma'am.